Okay, good morning. I think we're going to get started. I know some people are having some technical issues, but hopefully they'll be able to join us soon. My name is Elisa Scally. I'm a partner with the Employment Labour and Equalities Group with Gowling, and I'd like to welcome you to our sixth webinar of our 2023 webinar series. Before we begin our program, I would like to acknowledge that because we are based in different cities and provinces across Canada, we are located in different traditional Indigenous territories, some of which are covered by treaties. I encourage all of us to take a moment to reflect upon and acknowledge the land upon which we are living. If there are any Indigenous people attending the webinar, please feel free to welcome to share your home community in our Q&A so that we may also recognize you. Okay, so during our webinar today, we will be discussing the pitfalls and perils of fixed-term contracts. And to guide us through the discussion, we have the lovely Melanie Pollowin and Amy Derricks. Both Melanie and Amy are partners in our Ottawa office, so I have the pleasure of working with them on a daily basis. And I know, this is one thing I know about them for certain, is that they're very passionate about employment law, but they do have other passions. And I thought I'd just ask each one of them what their passion is to share with the group. So Mel, do you want to start? If you didn't have a career in law, and I know you're very passionate about law, what do you think you would be doing today?
Something completely and totally different. I would be a children's book writer and illustrator.
I love that. And I think there's still time, because I think once a grandbaby comes along, you might be putting pen to paper for that baby book. Maybe. How about you, Amy?
So no wonder we get along, Mel. I would be a kindergarten teacher. So soul sisters, Mel.
That's amazing. Before we begin this presentation, which I know is going to be exciting and interesting, even though we're talking about fixed term contracts, I know Mel and Amy can achieve that to make this exciting. There's just a few boring housekeeping items that I need to address. So the PowerPoint you will be seeing today will be sent to you following the webinar, so no need to worry about that. You will be receiving that in your inbox. The webinar is also being recorded, so you will be also able to access the recorded session following the webinar today. That will be on our webpage, and it will also be, the link to that will also be sent to you with the webinar presentation. If you would like to view our earlier webinars that were also recorded, we're going to include a link in the chat where you can access those previous webinars. Finally, if you have any questions throughout the presentation, we're going to do our very best to address your questions as we proceed through the presentation. And please do not hesitate to add your questions to the Q&A. So now I will hand it over to Amy to get us started.
Thanks, Elisa. All right, next slide, Miss Mel. Here is our roadmap for today. I want to share a special thanks to Angeli Lee and Stefan Crick, who are ArtiClean students at Gowling WLG and who helped with our presentation. A special thanks to you. And here's what we're covering today. And I propose that we jump right into it, Mel. So we'll start with some fundamental concepts. We're going to talk about what indefinite employment agreements are and what fixed-term employment agreements are, starting back at the basics. So first off, most employees are hired on an indefinite basis. What do we mean by that? We mean their employment agreement doesn't include an expiry date or an end date of employment. In my brain, when I think about indefinite employment agreements, I think about Buzz Lightyear and what he would say, to infinity and beyond. So what we must understand with indefinite employment agreements is there's an implied common law presumption that reasonable notice will be provided to an employee in the event an employer is terminating them on a without cause basis. So what are we talking about? Next slide, Mel.
Oh, I apologize.
Hey, it's like 8:30.
Oh,
We're good.
this is like, honestly, you people are gonna hate me. I am having a little bit of difficulty with my, okay.
So
All right.
when we're talking about common law reasonable notice, one slide earlier,
Yes.
Yep. When we're talking about common law reasonable notice, we're talking about a notice period that is dictated by what courts have awarded in past similar cases. And a case called Globe and Mail and Bardall.
Thank you. Sorry.
You're good. Okay. So the Bardall versus Globe and Mail case tells us what the Bardall factors are when we're trying to assess what the reasonable notice period is. So that case tells us that we look at the character of employment. So for instance, the employee's title, their length of service, their age, the availability of similar employment, considering their experience, training, and qualifications. So the common law reasonable notice period takes these considerations and others into account in looking at what that notice period should be based on what courts have awarded in other similar cases. And this presumption applies to indefinite employment agreements, okay, unless it is rebutted. And it can only be rebutted if it's done so in writing, in an enforceable manner, okay, that specifies some other notice period. And of course, that other notice period has to be compliant with the applicable employment standards legislation. Next slide, Em. I hope we have not made you nauseous with our slide turning. But you're all awake now, which is good news. So when we're talking about fixed term employment agreements, we're talking about an employment agreement that specifies employment for a fixed duration, or for instance, a project that will last for a specified period of time. And our courts tell us that the wording required to constitute a fixed term employment agreement must be unequivocal and explicit. And when we're considering whether we've achieved that level of clarity, okay, if there's any ambiguity, the courts have made it quite clear that that ambiguity will be strictly interpreted against an employer's interest, okay? So when we're talking about true fixed term agreements, depending on the duration of the term, which we'll get to in a moment, ESA termination entitlements won't apply. Rather, the fixed term employment simply expires upon the expiry date. Again, when we're talking about true fixed term agreements, that common law presumption that we just reviewed also won't apply. The fixed term just expires. Now, an employee whose contract isn't renewed at the conclusion of the true fixed term arrangement is not dismissed or terminated. Again, employment simply ceases in accordance with the terms of the contractual expiry date. So going back to the question of when will those statutory entitlements trigger, we look to, in Ontario, the Employment Standards Act that sets out the following rules. So if the initial term exceeds 12 months, if employment ends before the scheduled expiry date, or if the employment has continued for 3 months or more after the scheduled expiry date, then we must understand that our statute says the same statutory termination entitlements would apply as if it had been an indefinite employment agreement from the start. Okay. We're going to talk about the Steele versus Corporation of the City of Barrie case. This case involved an employee who is employed by the city for a period of about 3 years. The employee was an IT manager, and the issue in this case was whether that employee was employed pursuant to a fixed term contract or an indefinite employment agreement. And it was the employee's position that the employment agreement was ambiguous, okay? It was the employee's position that the city's conduct and its representations that it had made to the employee over the course of employment had led him to understand that his employment was indefinite as opposed to a term contract. Now, on the other hand, it was the city's position that the employee was employed under a fixed term contract. And that fixed term was an initial 2-year period, and it was then extended on 4 separate occasions until it eventually expired. So with that position, the city said they didn't owe this employee any obligation to provide severance pay, notice of termination, pay in lieu thereof. And so again, in this arrangement, there were 4 consecutive extensions issued. And so the court, next slide, the court looked at the relationship, the contractual documentation, and found that the parties had clearly established a fixed term arrangement. And the court did not accept the employee's position that he could have reasonably understood that his employment was indefinite in nature. And they looked at the documentation here. They looked at the job posting, they looked at the employment letter, they looked at the notices of extension, and all of that documentation made it clear and unequivocal that the employment was temporary or fixed in nature. Next slide, M. So this employee wasn't an indefinite hire, according to the court, and the court felt that there was unambiguous terminology that established that the relationship was fixed, okay, as opposed to indefinite. And so where there isn't ambiguity in fixed term contracts, as well as the successive extensions where applicable, employees can be found to be under a fixed term contract. But as you're going to hear more and more from M in a few minutes, don't get excited about this case, because successive extensions or renewals can be very problematic. And so we'll get into that a little bit more, but don't take the Steele case, okay, for the proposition that you ought to extend multiple renewals of a fixed term, okay? It was successful in this case because of the clarity of language, okay? But it is a very risky practice to enter into, and we're going to dig into that in a minute or two.
Thanks, Amy, and apologies to everybody in advance. We have learned, do not let Mel control the slides. All right, we're going to step back now and talk about why you should, when and why you should ever choose a fixed term arrangement. So let's start with this. What are you thinking? What is your rationale for this particular hire at this particular time? And these are the reasons that we often see. First of all, sometimes employers or managers like to use it as a test run. Let's see if we like this person or not. That is not a good reason to do that. You can have somebody on an indefinite contract, and if you have good, strong termination provisions that scale up over time, including one that says if it's in your first 3 months, you only get this tiny little pittance, that's the kind of a solution to wanting a test run from somebody, not a fixed term contract, because of the potential for backfire. And we'll talk about that shortly. Is it because you're hiring for a project, or for that matter, an organization where the funding is uncertain, or the need for the job is uncertain, or the duration of the project itself is uncertain? Again, that is not a legitimate reason to do that. What you want to do is hire indefinitely most of the time, and have a good, strong termination clause in your contract. Are you hiring to cover a specific absence, like a maternity or parental leave? Or is it a purely seasonal job? Are these, summer students, summer hires? Is it a purely seasonal job at another time of year? Landscapers, shovelers, things like that. That's a legitimate reason to hire somebody on a fixed term basis when you have a box and you're certain about or reasonably certain about the duration of the box. That's a legitimate time to use a fixed term contract. You have to be careful about doing it, but that's legitimate. Are you staffing up to meet a temporary need? Again, if you're positive it's brief and it's fixed, that can be a legitimate need or a legitimate reason. If you're not sure how long you might need them, you maybe, and a lot of the times arguably are better off giving yourself the flexibility so that you don't have to keep running up against expiry dates and extension decisions and things like that. Is this, and this is where we very commonly see this, it is very, very common in the M&A deal, merger and acquisition deal context, for the key employees who are also sellers to, as part of the deal terms, agree to stay on for a particular period post-closing. And it is very common for the buyers in that situation to ask for or insist upon a 1 year or a 2 year or a 3 year employment agreement post-closing. Again, there are very, very, very many cons against doing that. There are a couple of pros in terms of doing that. There are other ways to address that need, the fact that somebody's only, or you only want them sticking around for 3 years. And so I suggest that most of the time, that is not a good time to use a fixed term contract because the risks of if something goes wrong are very expensive. So at the end of the day, a lot of the time, what you're trying to do can end up backfiring on you. For example, sometimes employers try to use these fixed term agreements, a sequence of fixed term agreements, because they believe somehow it helps them avoid the statutory entitlements and it helps them avoid the common law reasonable notice termination entitlement. But if a contract is for a fixed term, and in practice, what you actually do is do a bunch of or a series of back-to-back renewals or auto renewals, so that essentially you are just bopping along and continuing the relationship without any interruption, without any real change. Maybe you sign new paper each time, but there's no negotiation, there's no this, it's are we good? Good, great, sign here. Then in that situation, a court is going to look at the underlying intentions and expectations, and the court may find that that back-to-back or series or sequence of contracts creates enough ambiguity about what your real intentions were to render to find that to find that it's indefinite employment and to render the fixed term unenforceable. If you have a contract that purports to be for a fixed term and the court finds that it is not a fixed term contract, then the relationship is deemed to be an indefinite employment relationship, and the common law reasonable notice or presumption applies, and boom, what you were trying to do just backfired on you. So the end of the day, and we got this from what Amy was talking about in the Steele's case, at the end of the day, if you're going to use a fixed term contract, it has to reflect the real nature of the relationship, the true expectations and reasonable expectations of both sides. And if you're using it for a different purpose, then at the end of the day, if there's a dispute when the relationship falls apart, a court is going to dig into the entire history from posting up to termination to decide whether or not that was in fact your intention, or even if it was at the start, whether that intention changed over time. And if the court believes that the intention ultimately, by the time you terminated, that the employee had a reasonable expectation that it had essentially become an indefinite relationship, the court is going to go that way and award a big chunk of change to your departing employee. And the seminal case in this dates back all the way to 2001, and some of you will be familiar with this. Essentially, this was, and it's very common with gyms and pools and various other of these places to do these back-to-back fixed-term contracts for their people, or to do so-called independent contractor agreements. But essentially, 16 years under a series of 15 back-to-back one-year contracts. The paper was just a formality. Everybody behaved as though the relationship was going to be an enduring and permanent one. You get to year 16 and the employer says, oh, sorry, we don't need you anymore. Here's a 3-month severance offer. Shockingly, the employee sued. And at the end of the day, what the court decided was this. If the underlying reality is not that it is intended to be a fixed term relationship, then the court will give effect to the underlying reality. The court will say, this is indefinite. And as I said, the employee will get a large chunk of change based on the entire duration of the relationship, just as if it had been indefinite from the very beginning. The court is always going to look at the paper, the process, and the practical reality of the relationship when the court is deciding whether or not it's truly fixed term or it's not. A similar case in 2015 went up to the Ontario Court of Appeal, and this was teachers. Again, schools do this too sometimes. 3 different teachers, each of them employed for a different number of years, each of them employed for successive years and multiple years, relatively long-term employment for these people. School was having financial problems. School told them, oh, we're not going to renew you again. And the school's position was, of course, your contract expired as you expected it to, and we're not giving you a renewal or extension, but so be it, we don't owe you anything. Shockingly, they sued. At the initial stage, the motion judge, so a summary judgment motion judge, found that the teachers were employed for an indefinite period of time, awarded them reasonable notice. But one of the things, and this isn't relevant to us, but it is relevant to life, and it is interesting. One of the things the motion judge did was they said, hey, the school's troubling or troublesome financial position is a factor I can take into account in reducing reasonable notice. So I would have given you this much, teachers, but I'm only going to give you this much because of the school's financial position. Went up to the Court of Appeal. Issue was, how much reasonable notice should they have? And should the judge have reduced it because of the school's financial position, which the court ultimately said, these people all deserve 12 months reasonable notice. And sorry, school, your financial position does not let you off the hook. And it's something very important for you to remember. For those of you who are not-for-profits or government-funded organizations with a funding uncertainty or tightened funding, you can't rely on the fact that you have financial problems as an excuse to use fixed-term employment agreements if otherwise the circumstances suggest that you shouldn't be doing that. So something to keep in mind. All right. So now that we're seeing what can happen if your fixed term isn't really a fixed term, how do we protect your intentions if your intention is this is supposed to be genuinely a fixed term arrangement? How do we protect your intentions? Well, the first thing you need to understand is this. If it's a fixed term contract and it either has no termination provision, which your employment lawyer's head will explode if you ever show them one of those, or it has a termination provision that for any reason is unenforceable, and anybody who joined last time's webinar about beyond reasonable notice or has worked with any of us knows how difficult it is to enforce contractual termination clauses. So either there's no termination clause, or for whatever reason it's unenforceable. If you want to end the employment before the natural or the scheduled expiry date of the term, if there's a dispute, a court is going to give that employee an amount equal to what they would have earned, both in salary and other perks, for the entire unexpired remainder of the term. Now think about that. If you have a 3-month term agreement, not great, but not terrible. If you have a 3-year term agreement, one of the cases coming, we'll talk about that, or a 72-month term agreement, one of the cases coming, we'll talk about that, and you are early on in that relationship, that is a lot of wasted money. You might as well not terminate the person and make them work out their term and hope you get something useful out of them. So, bearing in mind how hard it is nowadays to enforce a contractual termination provision, this is what's going to happen to you if something goes wrong with your fixed term employment agreement termination clause. Not a happy result. So,
Oh, Mel,
Yeah.
sorry, I don't mean to interrupt you, but there's a question that I'd like to pose that from the from an attendee that is related to a comment you just made, that an employee will get all of the perks that they would have otherwise received. And the question from this person is, in that termination package, would it also include benefits that they did not receive because the relationship was misclassified as a fixed term, I guess, contract as opposed to indefinite term, meaning if they worked overtime, vacation pay, and all those types of other benefits that they may not have received potentially.
okay. First of all, on the issue of overtime, overtime has nothing to do with whether you're fixed term or indefinite. Overtime entitlements are purely a function of what province do you work in and whether you are in an exempt from overtime position in this job. So overtime entitlements or overtime liability this is not relevant to that. That's a separate issue. If you did a fixed term hire, typically with fixed term hires, you don't put them on your benefit plans, you don't put them on your bonus plans, you don't give them stock options. Some organizations do, especially depending on the length of the term and also on how hard it is from a recruitment point of view to attract people in for a fixed term. But most organizations, you're going to get hourly pay or salary in a fixed term, and you're going to get vacation pay. Because again, under the employment standards legislation, vacation pay entitlement has nothing to do with whether you're fixed term or whether you are indefinite. The vacation pay entitlement is there. Vacation time entitlement depends on whether you're fixed term or indefinite, or it can be affected by whether you're fixed term or indefinite if the term is under 12 months. So in that situation, a court will not say, you misclassified that, or you treated this as fixed term instead of indefinite, and that's why you didn't put the person on your benefit plans, and they should have been on your benefit plans, and therefore I'm going to award them compensation in lieu of the benefits they should have gotten. A court will not do that. The court will award based on what the contractual compensation elements were, what the value of every contractual compensation element they would have received if they had continued to work for the entire remainder of the term. So it's similar to a reasonable notice entitlement in assessment in the indefinite situation, as many of you will have been caught in that kind of a thing. Court's going to look at, was this person on the benefits plan? No? Okay, don't have to think about it. Was this person in the group RRSP? No? Okay, don't have to think about it. Were they on a bonus plan or commission plan of any kind? No, don't have to think about it. Were they getting salary? Yes, have to think about that. Did they have a car allowance? Yes, have to think about that. They've got a statutory vacation entitlement or another vacation entitlement. Yes, I have to think about that. So hopefully that answers that question. Okay, so Again, we're talking about what can you do to protect your contractual intentions when you want it to be fixed term employment. What we're about to walk through are a number of steps and considerations that you have to think about in order to have the best chance of defending your fixed term intention. It is not all about the paper. As Amy has already said, extensions and renewals, and we've seen extensions and renewals matter too. A court's going to look at everything that you did from the outset of the relationship, from the job posting, all the way up to the point of termination. So the process you followed, what you did, when you did it, is as important as, and the practices, how you're treating this person, how they're showing up in your org charts, how you're portraying them to the world. Those things, process and practices, matter as much as and often more than what the paper says. A lot of you may be sitting here thinking, this is a very familiar discussion, and this is the same kind of advice and discussion that we often have when we're talking about independent contractor versus employee misclassification. A lot of the same considerations. Your friendly employment lawyer, especially nowadays, is your best friend. So if you haven't very recently done this, work with your friendly employment lawyer to identify what process are you using for your temporary hires right now, from start to finish, posting onward. What paper are you using for hirings, extensions, renewals, termination related templates, what kind of communications, onboarding? What are you doing for your temporaries? What are you using for your temporaries, and how is that distinguished from what you're using for your indefinites? Identify what the best practices and protocols are, implement them, police them, enforce them, make your managers follow that process. Otherwise, they can torpedo all of your efforts. So you're updating your paper, you're reviewing your processes and practices, and you are putting best practices into place. So part of that review of best practices and processes is this. You're looking at policies, you're looking at your benefit plans, you're looking at your incentive plans. Make sure you know internally, as you're bringing people on, as you're generating offer letters and you're onboarding them internally, which of these things will this particular temporary hire have access to or not have access to? Somebody who's coming on for a 3-month term is typically not going to have access to benefits or bonuses or incentive plans of any kind. Somebody who's coming on for a 1.5-year term to backfill a VP absence, you might very well be giving them access to benefits and to a bonus plan or incentive or some kind of completion bonus as a way of getting somebody good into the door, given that it's a fixed term hiring. So make sure you know who's getting what, and make sure you look at what those things say about who's getting what. Make sure you have clear protocols internally for when identifying, again, when they can't be on a plan. Sometimes your benefit plans won't allow fixed term employees to be on the plan. Sometimes benefit plans require every employee to be on the plan, depending on what your plan is. So can they not? Do they have to be? Do they not have to be? Will you let them? Will you not let them? Again, you're looking at all of these things: benefit plans, pension plans, group RRSPs, any kind of incentive plan, cash or equity-based, all kinds of other perks. Many handbooks or policies talk about we give our people tuition assistance. We give our people paid leaves for bereavement. We give our people paid jury leave. We give our people the top up for MATs, maternity and parental leaves. But you need to clearly distinguish, is that everybody or is that not your temporary people? And you need to make sure that everything you are clear about it, and that the documentation clearly distinguishes when they will or will not be eligible for these kinds of things. So you're basically doing an entire audit in order to make sure that there's nothing somebody can point to that says, well, wait a minute, I got the same leave, the same benefits, the same tuition assistance as everybody else. I was on the same plans as everybody else. In terms of the paper, here are some do's and don'ts. If you have auto renewal clauses in your templates, get off this call at 10 o'clock, go and scrub them out. Never, ever include auto renewal clauses. do include an explicit statement that if or once employment ends for any reason whatsoever, the employee will have a duty to mitigate the loss of the employment. We'll talk about why that is, but that's an important statement. They don't automatically, fixed-term employees, we will talk about it down the line, don't automatically have a duty to mitigate loss of their employment. Duty to mitigate, for those of you who are thinking, what is this? Generally speaking, it is a principle of contract law, not just employment contract law, but contract law, that if somebody breaches the employment contract, the injured party has an obligation to take reasonable steps to minimize the loss and minimize the damage. Employment context, somebody wrongfully dismisses you, you have the obligation to take reasonable steps to mitigate the loss of your employment by taking reasonable steps to find and secure new comparable employment. That's the duty to mitigate. So one of the ways that you can help protect yourself is to include a contractual duty to mitigate. Whoops, back I go. Oh, Melanie. Previous. All right, well, I apologize. I'm really having some very difficult problems with my technicalities. Another thing is to make sure your termination clauses include an express waiver of reasonable notice. And anybody who works with us know that we already do that in indefinite hire agreements, but we want that in our fixed term agreements. I acknowledge that on termination, the entitlements set out in this clause, whatever, are my entire entitlements, and I hereby waive any entitlement to common law reasonable notice. You also want them to waive any entitlement to compensation or damages for the unexpired remainder of the term. And make sure that in your renewal and extension documentation, you identify all the things that need to be in there that wouldn't be in there for the first contract new hire. If you're extending or renewing somebody, don't ignore the fact that there is a previous contract that has already been in operation. Acknowledge that in the extension letter or the amending letter or the renewed contract or the new agreement that they're signing. Acknowledge the prior contractual and make sure that your termination clause takes into account how that period might impact on their termination entitlements. So those are the things you need to do in your paper. You're also going to review and look at and standardize, centralized to help control best practices and protocols for making the smart initial choice when you're choosing between posting for an indefinite or posting for a fixed term hire. Make sure you have a series of good questions that you ask yourself, your team, your managers when they come to you and say, I want to hire somebody for 6 months to do A, B, C, and D. Make sure that you identify the smart choice for the term duration. Ideally, in order to preserve or optimize your chances of fixed term hire being treated as a fixed term hire and avoiding the termination obligations under the statute and under the common law, ideally, you're looking for a term that is 1 day less a year. Make sure that you are careful in what you say in your posting and recruiting, both what is posted and in the documentation that you give anybody and what people tell them. A lot of the time, what employers say in a posting and what the hiring manager says in the interview are inconsistent. I know it says it's only for a 6-month term, but we're positive little Sally Sue won't come back after she has her once she has her mat leave. We're positive she's going to choose to stay home. And so you can be pretty sure this is going to turn into a permanent job. That is fatal. So make sure that you've got good you teach people good best practices and protocols for those kinds of things. Make sure that your process for contracting with them, when you send it out, getting it signed back, and onboarding them, what policies they do and don't see, whether they do or do not enroll in certain things. Make sure those are good and consistent with your intention. When it comes to deciding Are you going to extend? Are you going to renew? Or do you need to terminate early? Make sure that you've got a good, robust system in place for considering those needs well in advance, or as much in advance as you can, of actually taking that step. And if you decide to extend, renew, or terminate early, make sure you've got a good, robust process and practice for how you're going to implement that. Another thing that is very helpful is making sure that you've got a good set of protocols for pre-expiry communication plans. So what do I mean by that? Well, first of all, make sure you're controlling your messaging before and during the term so it's consistent all the way across. Don't let anybody promise or speculate or imply there's going to be an extension, there's going to be a renewal, or we're going to convert you to indefinite. Don't let anybody raise that, discuss that, unless there's already been a firm decision and you've got paperwork underway ready to present. Would you be interested in a 6 months extension is not the same thing as saying, hey, we're going to offer you a 6 month extension. Okay, great. Would you be interested in converting from a temporary into a permanent job in this role? Is a different thing from saying, hey, we're absolutely going to keep you on permanently. We'll get some paper done later. So make sure you're careful about that communication and that messaging. And don't let anybody do it orally. Those of you who are in charge of hiring and who've worked with us about hiring processes, protocols, and templates know that if you tell someone you're going to hire them, or you're going to extend them, or you're going to renew them, and treat it as though it's a done deal, if you put paper in front of them afterwards, that paper may very well be useless to you. And so you've got to be careful about process. So I talked about pre-expiry communications. This is where your calendar and a strong tickler system is your second best friend after your friendly employment lawyer. The second you onboard any fixed term hire, this is true for independent contractors too, calendar the scheduled expiry date, work backwards from that calendar and put a series of tickler reminders into your calendar. Again, a 3 month term, you're not going to have that many reminders. 6 month term, 12 month term, 24 month term, you're going to have a lot of reminders so that you just pay attention to what is going on. Do we need to make a decision? Do we need to tell anybody anything? Work backwards from that. You want to have a tickler in there so that you check in. Does somebody want to extend or renew this term, or is it going to expire as originally scheduled? Check in and make sure somebody actually makes a final decision about that. And then you prepare. So again, calendar the preparation of any documentation to document that decision, to offer the extension, offer the renewal, so that it can be delivered, I say here, at least 2 weeks before the scheduled expiry date. If this person's been there a long time, earlier is better. If they've only been there a very short time, let's say under a year, then 2 weeks before is ideal, okay? And you make sure, just like with any employment offer, that any extension or renewal offer is accepted before the scheduled expiry date, not after the fact. There are ways to fix it if you don't get the timelines right, but a broken leg is never as good as the unbroken leg, and a fixed contract, a fixed contract, pardon the pun, is never as good as a one that was properly signed up in the first place. Ticklers are also going to need to include reminders that, again, if there's no decision to extend or renew, or if there's no decision yet to extend or renew, you want to reach out to the person to say, oh, by the way, just a reminder that your temporary employment term is scheduled to expire on November 3rd. And again, I've suggested some time frames here. What you want to do is you want to make sure that the reminder, and it doesn't have to be formal, but it has to be written. Written means email, memo, or an actual physical piece of paper. Make sure it's delivered early enough so that in the clock, the remaining time until the scheduled expiry date matches or exceeds your worst case under an employment standards notice period. So if the person's been with you for 3 years and they're scheduled to expire November 30th, you want to get a reminder out to them at the very beginning of November, at least 3 weeks before the scheduled expiry date, so that if worse comes to worse, you've essentially initiated a termination notice by saying, as a reminder, your employment's ending November 30th, and that'll count. You want to make sure that you tickler initiating the offboarding process a few days before the expiry date. I've had employers that reach out to me the day the contract expires to say, oh, we're not going to renew or extend them. What do we do with them? And it's like, have you not spoken to this person about this? Have you not given them any idea of what's going to be happening? So again, it should be in advance. In all fairness, let the person know so they can start making plans. And again, to prepare a formal confirmation of the expiry, ideally to be delivered at least a week before the scheduled expiry date, but in a worst case scenario, the day of. So those are all things that you can do to try and ensure that when the court goes back and reviews everything you did from start to finish, you have at least kept a consistent message and you've taken reasonable steps to remind the employee, you're just a temporary employee, you're just a temporary employee, it's going to come to an end. And here's, I just gave you a very, 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 very simple sample of what you might use for a reminder email in advance here. It's a great idea, unless you hated them, to offer either reference letters or employment confirmation letters to help in their job search. They may or may not want that or need that, depending on the circumstances, but it's a great idea to offer it. Very consistent with the intention that it was a temporary employment agreement that's about to expire. What are the best practices for extensions and renewals? Well, we'd really rather you didn't, but if you're going to, and we understand, sometimes it's inevitable. It is inevitable sometimes that it has to happen. So you need to be, it's the same kind of care and caution that you have to consider when you are doing a new hire, except you have to remember this is not a new hire. And one of the things we see over and over again is people putting the new contract in place that does not say anything about the fact that there is a prior contract, or this is superseding a prior contract, or that there's been a period of employment that started X and has continued unbroken. So again, it is not a new hire. I encourage you to work with your friendly employment lawyer to update your extension renewal documentation and have a set of documentation that applies only when it's an extension or renewal, not for the initial contract with a brand new hire that you've never worked with before. So again, when you're going to extend or renew any individual, you want to look at the entire employment history and the current circumstances of that particular individual and all the paper that you've used so far, because that is going to influence what needs to be in your extension or renewal documentation. You need to identify, is there a risk that this extension or renewal is going to tilt the scales into, oh, now we're really getting into risk territory for indefinite hiring? Is this the time, this extension or renewal, going to tip them into a situation that Amy talked about earlier, where ESA termination protections will apply no matter what? Is this a situation that's going to, again, promote an expectation that it really is sort of these extensions or renewals are formalities and really is an ongoing relationship, an indefinite relationship? If it tips into indefinite under the ESA, that doesn't affect vacation pay entitlements, but it affects vacation time entitlements. And obviously it affects termination entitlements. Put your new paper in front of the person, and as with any hiring, any extension, any renewal, do it before the expiry date. Make sure they've got a reasonable signing deadline, and you get the paper all signed up before the expiry date so that we don't have to try and fix it. What are best practices for pulling the plug early? Again, we get it. Nobody here is saying to you, you have to have them there till the end of the term. What we're saying to you is pulling the plug early before the scheduled expiry date of the term is riskier than you thought it would be, and therefore you need to follow some best practices. Again, good idea to work. It's the same process, the same evaluation as with any termination, any indefinite employment termination, you have to still look at all the same stuff and worry about all the same things and the same considerations. So again, work with your friendly employment lawyer to make sure you've got a good process for this review and analysis, assessment, recommendation process. Make sure you've got time to look at the entire history, look at all the paper, look at the current circumstances, identify the risks of whether it's going to be considered indefinite or if there are termination clauses that you know going in are not going to be enforceable, and game plan if there's actual or potential claim for entitlements under statute, what the contractual termination clause says. Make sure you're at least adhering to that. But you're also considering, are there any statutory entitlements that we have to give them? And do we, in this situation, should we be making some kind of offer because we have exposure for common law reasonable notice? So over to Amy.
Thank you so much, Mel. We are friendly employment lawyers, aren't we? Okay, so I'm going to talk about the costs of getting fixed term agreements wrong. And as the image indicates, you can break your piggy bank in a big way. We are going to talk about the Howard v. Benson Group Inc. case, which was a rude awakening for employers coming out of our Ontario Court of Appeal. So this case involved a former employee who was working at an automotive service. He was 57 years old and earning about 60 grand a year. He signed a fixed term employment contract spanning 5 years. That's so bad. And the employer terminated this employee's employment 23 months after he started. And so, as Mel would say, shockingly, the employee sued for breach of contract, seeking the unexpired remainder of that term, which was like over 3 years' salary. And so the employer argued that their liability was limited to 2 weeks' salary in lieu of notice per. They had a termination without cause provision that attempted to limit entitlements to ESA only. The motion judge said that the termination clause was unenforceable. They took a close look at it. They found that it was ambiguous. And the motion judge then examined the remaining provisions in the employment contract to determine if it demonstrated any intention to displace, remember, that common law reasonable notice presumption. And the motion judge said, nope, I don't find any intention to displace that. And so the motion judge rejected the employee's argument that he was entitled to contractual damages for the remainder of the term. Okay, but this was appealed. And there were 2 issues before our Ontario Court of Appeal. First, whether the employer was liable for common law reasonable notice damages or that unexpired remainder of the term. And the second issue was whether the duty to mitigate was triggered. And Mel so helpfully explained that concept of the duty to mitigate. Thank you, Mel. So dealing with issue number 1 before the Ontario Court of Appeal, common law damages or remainder of the term. The Court of Appeal found that the employee was entitled to his salary and benefits for that an unexpired remainder of the term. So that was like a 3-year payout. So brutal. So issue number 2 that the Ontario Court of Appeal dug into was that duty to mitigate. And to make matters worse, not only was the employee entitled to that 3-year salary and benefit payout, okay, the Court of Appeal said, and there's no obligation to mitigate in this circumstance because the fixed term nature of that employment agreement that didn't have, okay, the ability to enforceably pull the plug early, okay, fixed damages for that remainder of the term, okay? So no duty to mitigate was found by the Ontario Court of Appeal. So that's a large payout and no obligation for the employee to look for other work during that period of time. So what do we learn from this alarming case? in the absence of an enforceable early termination provision, if an employer dismisses an employee prior to that expiry date in a fixed term arrangement, they will be liable for damages in lieu of the unexpired remainder of a fixed term without any duty to mitigate. So if anything makes you pay attention, it should be this case. That's a massive amount owing to that employee. So sometimes we're asked, what if the circumstances of a case suggest that a court would deem an employment relationship to be indefinite? And so we look at, okay, so if the unexpired remainder of the term is longer than what the reasonable notice period would be assessed to be, ironically, it will be in the employer's best interest to take the position that the fixed term relationship actually became one deemed to be indefinite, right? Because if the unexpired remainder of that term is longer, or it's going to be more costly a payout than what the common law reasonable notice period is going to be, ironically, you want to say, yeah, it became indefinite and common law applies. The employee, however, as we saw in Howard Benson, is going to want to say, no, this was fixed term. I was guaranteed employment for however many years. You terminated me early. There wasn't an enforceable way for you to terminate me under that fixed term agreement, and I am owed the remainder of that fixed term period. So the irony.
Thanks, Amy. Just to bring you up to date on the duty to mitigate, Howard and Benson was 2016. Well, employment lawyers are an optimistic bunch, and we're always hoping that a case that we think has a horrible result will end up overturned or undermined by subsequent cases. So we're going to just talk about very quickly two relatively recent cases that deal with the duty to mitigate. First one is the Terrace case. So last year, fixed term contract of 3 years. A few months into it, employer terminates early. Employer argued that termination clause was fine, and therefore that they only owed ESA notice and nothing more. This one got, you should pardon the expression, Waxdaled. And for those of you who aren't familiar with the Waxdale case is a decision several years ago that basically said that if there is a problem anywhere in your set of termination provisions with any clause at all, then that will affect all the rest of the termination provisions. And the specific problem was that the termination for cause provision had the potential to violate employment standards in requirements. Without getting into that, because those of you who did the webinar last time know all about that, the point is the termination clause, contractual termination clause, was found to be unenforceable. And so, because the termination clause was found to be unenforceable, all the termination clauses were unenforceable, and the court followed Benson, 2016, still alive and kicking us in the teeth today, entitled to payment for the entire remainder of the term with no duty to mitigate. So a lot of money. Now, in all of the cases we've talked about so far, including the next case I'm going to talk about, there was no statement in the contract that spoke to mitigation. With an indefinite hire, the duty to mitigate is implied by the common law the same way that reasonable notice entitlements are implied by the common law. With a fixed term agreement, the duty to mitigate is not implied by the common law, but there's nothing to stop you from having a contractual term that says, I, employee, agree that if my employment ends for any reason whatsoever, I will have a duty to mitigate the loss of my employment. And I don't know what a court will do with a statement like that, but at least it gives you something to argue on. These people had no wording that they could rely upon to try and counter the general supposition that a duty to mitigate won't apply to a fixed term contract, which is why one of the recommendations we make is that you include that. So the next case we essentially threw in Monte Rosso is an independent contractor case. We're not dealing with independent contractor agreements in this. That's a whole nother webinar with a whole other set of issues, but there are a lot of parallels in terms of do's and don'ts and risks. 72-month term, 72 months. Even in our court's most generous moments, our courts have never exceeded, I think the maximum was 33 months in a reasonable notice award, which was exceptional and unusual and almost never happens. Generally speaking, if a court's going to give a reasonable notice award to anybody, it's going to cap out at 24 months, absent very exceptional circumstances. There was a case that we all heard about yesterday that is picking away at that, but still the law of the land for purposes of today. Independent contractor relationships are not the same as employment relationships. Different considerations apply. The theory about the power imbalance is that employer-employee, there's a significant power imbalance. The theory about independent contractor relationships is there is much less of or no power imbalance. We all know that's not necessarily true, but that's the theory, and that's why the law treats them differently in many ways. In this particular case, again, contract didn't even have a termination provision. Poof! What were people thinking? Always have an early termination provision. Always, 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 always. Or else this is what happens. Trial judge awarded compensation for the entire unexpired remainder of the term. Company appealed. And the trial judge did say this. The trial judge said, the appeal court said, the trial judge conflated independent contractors and fixed term employees. It is true that fixed term employees do not have a duty to mitigate, but the general contractual obligation to mitigate does apply to independent contractors. So, Court of Appeal said, yes, he was entitled to damages measured by the entire unexpired remainder of the term, but he did have a duty to mitigate. So if there had been mitigation earnings, that would have reduced the payout to him. Or if he had failed in his duty to mitigate, that would have reduced the payout to him. When a court's looking at the duty to mitigate, the court will consider whether or not the individual took reasonable steps to mitigate the loss of their employment, or whether they lay on their couch and binge watched on Netflix. And if the court concludes that someone did not take enough reasonable steps to mitigate the loss of their employment, the consequence of that is that it will reduce the damages that the person would otherwise get. And in some cases, in egregious cases, if they took no steps at all for a prolonged period of time, it may actually disentitle them to those damages, those reasonable notice damages. Back to the independent contractor context, whenever you are arguing that someone has a duty to mitigate, the person who has to prove failure to mitigate is the person who has to pay the money. So in this case, the company did not lead any evidence, did not persuade any court that there was a failure to mitigate. And that is why at the end of the day, both at trial and at Court of Appeal, this person ended up getting a chunk of change equal to the entire unexpired remainder of their contract. So takeaway is, on the employment front, fixed term contract, they get a payout for the entire remainder, no duty to mitigate. So if they get a great new job day after you fire them, bonus. Independent contractors do have a duty to mitigate, and therefore if they get new engagements or new jobs after you fire them, if you're still negotiating, that's going to matter. And over to Amy.
Thanks, Mel. Okay, best practices. We're going to leave you with 5 best practice recaps. Number 1, you heard it from Mel. We're going to say it again. Give yourself lots of time before the scheduled expiry date. 2, consider what you're going to do after the expiry date, if anything. Are you offering, for instance, a short time-limited extension, a renewal? Or are you going to choose, hey, we need them, and this is no longer a term. This is actually someone who is indefinite, and we have to convert the paperwork to an indefinite hire. This has to be considered before, long before the expiry date, so you can paper your decision accordingly before the expiry date. You want to give that employee enough time to, if you are offering updated paperwork, you want to give the employee an opportunity to review it, consider it, respond to the offer before the expiry date, so you're not in a position of having to band-aid the situation after the fact. Okay. Takeaway number 2. You've heard it several times today, but it's worth repeating. Avoid multiple extensions or renewals of terms, okay? So to help minimize that risk of a court finding an indefinite employment agreement or deeming one to have existed, we say that employers should restrict themselves to a single extension of a fixed term and not engage in multiple extensions without there being a legitimate gap. And our common law doesn't say what is a safe gap. The courts, you've heard that they will look at the entire employment history, the relationship of the parties, the documentation in assessing whether there was or wasn't a legitimate gap. We certainly know from our Employment Standards Act that anything less than 13 weeks is just not a gap at all, okay? So multiple extensions or renewals significantly increase the risk that a court will consider the contract to be one of an indefinite hire, entitling the employee to common law reasonable notice in the event of termination. Takeaway number 3, actions are much, much, much louder than words. So the courts will look at the whole history of the employment relationship to determine if the employee could have reasonably and legitimately considered themselves to be employed on a fixed term or an indefinite basis. And we know that contractual labels, they might be relevant, but they're not determinative. If you're calling someone a fixed term employee who's been employed with you for 16 years, yeah, right. You saw the Sikoko case. So not going to be determinative to call them one thing, but act another. Takeaway number 4, police your fixed terms, okay? Mel gave you such helpful guidance as to how to set those tickler or reminder systems. So we must be careful to not overhold on fixed term arrangements. And what do I mean by overhold? Allow a fixed term employee to work beyond that expiry date, okay? Even if you let a fixed term employee work even one day after their expiry date without updating the contractual paperwork according to what you intend them to be as an employee, that can deem the relationship to be one of an indefinite hire, again, entitling the employee to common law reasonable notice in the event you need to terminate them on a without cause basis. Lastly, takeaway number 5, really think critically about whether a fixed term is or will continue to be the most suitable arrangement for your particular employee situation. Our guidance is only use fixed term arrangements if you genuinely believe that the role will not last longer than 12 months, okay? This is why in other situations where you think it could, right, or it's really not the kind of arrangement that's suitable for a term, right? It's not a replacement situation where someone's on mat leave. It's not project-based. You're simply trying to test them out. This is not a reason to issue a fixed term at all, right? In most cases, it will be safer to hire your people on an indefinite employment agreement with an enforceable termination provision that your friendly employment lawyers can help you with. So you'll get access to the slide deck after today, and Mel has helped create this chart that might be a handy dandy reference for you in understanding the termination pain points under the different agreements that we've talked about, and what the termination entitlement could look like, and whether there's a duty to mitigate triggered. So we hope you have found this helpful. We'll now take a look at whether there are any questions. And thank you so much for your time and attention.
Thanks, Amy and Mel. I think we've addressed most of the questions today. There's a couple specific questions, very specific questions I see in the chat. We're going to review those and we'll get back to you with responses, with some form of response following the webinar today. But I'd like to thank Mel and Amy for a very informative session. I do just want to remind everyone that the presentation today was not intended to be legal advice because this was a high-level overview. It's impossible to cover all the relevant details. It was basically Ontario-based, so we didn't cover the federal regime, and that was the intention of the presentation. If you have questions about that regime, you can contact your friendly employment lawyer to ask questions about that, and for specific advice on any other fixed term contract related topic, please reach out to your Gowling's lawyer or your employment counsel for those specific questions. So thank you again, and we hope you found this session informative. Our final webinar for 2023 is coming up November 30th. This will be a recap of the 2023 important decisions, so you're not going to want to miss that. So that look for our invitation. It'll be coming out shortly. Your feedback on these webinars is very important to us. We did have some technical difficulties. We recognize that today, but we got through it. And I think we got through it quite well. So, but we would love to hear your feedback. I'm hoping the next slide, Mel, will be the QR code. Let's see, cross our fingers. Yes, great. So this is the QR code. Point your camera at this code and it will take you to a link to a survey. And if you could take a few moments to complete that survey, we would truly appreciate it. So again, I hope everyone has a great day, and I hope you enjoyed our webinar today. Thank you.